There's a chill sweeping through the content creator world right now, and it's not from the algorithm. It's something colder and more calculated, and it's coming directly from Blake Lively's legal team. Just days after her case against Jed Wallace was publicly dismissed in a quiet but humiliating turn of events, Blake has unleashed a new offensive, this time not on celebrities, not on studios, and not even on journalists, but on content creators. Yes, the very people who gave this story its reach, its oxygen, and its heartbeat. And the timing, it's not a coincidence. This is about control, image repair, and an increasingly desperate attempt to shift the narrative. But the most shocking twist is that these subpoenas aren't just asking for commentary or emails, they're asking for bank records. Let that sink in. Creators who simply discussed public court documents and media coverage are now being asked to reveal financial information. Why? Because Blake's team appears to be building a new theory that talking about her online, especially in a critical tone, is somehow a monetized conspiracy against her reputation. But here's the truth, this isn't about money, this is about fear. Blake Lively just watched her own case collapse in front of the very audience she tried to silence. And now instead of accepting that the narrative moved beyond her control, she's trying to yank it back by any means necessary. And that's where this story begins. Jed Wallace was never a major player in the grand scheme of Hollywood. A well-connected fixer, maybe a consultant. Someone who moved in and out of boardrooms quietly, but for Blake Lively, he became a symbol, a scapegoat. When things started unraveling between her and Justin Baldoni, Wallace's name surfaced in confidential filings accusing her of leaking private negotiations, manipulating statements, and pushing a narrative favorable to Baldoni. But when the court finally looked at the evidence, something became stunningly clear: there wasn't any. No emails, no texts, no proof, just assumptions. The judge's decision to dismiss the case against Wallace was brief but damning. The language wasn't inflammatory, but there was insufficient evidence, a lack of material connection, and no reasonable claim to proceed. Those phrases hit like thunder in Lively's camp, and they knew it. Because once Wallace walked away, unscathed, the dominoes started to fall. What else had been assumed? What other names had been thrown into the fire with flimsy proof? And more importantly, who might be next in the days following the Wallace dismissal? A disturbing pattern began to emerge. Multiple independent YouTubers, TikTokers, and commentators, many of whom had covered Blake's legal battle. From the beginning, I started receiving letters from her legal team, not cease and desists, not even formal lawsuits or subpoenas, and not just any subpoenas. These were surgically detailed and deeply invasive. They weren't just asking for the content creator's footage or sources. They were asking for monetization data from platforms like YouTube, Patreon, and TikTok, personal banking records connected to brand sponsorships, communication between creators, and third-party researchers' email records with legal analysts who had spoken publicly about the case, and shockingly, lists of viewers who had donated or supported videos through platforms like Ko-Fi and Buy Me Coffee. To say the creator world was stunned would be an understatement. Some initially thought it was a hoax. Others laughed it off until they saw the actual court-stamped paperwork. Blake wasn't joking. She was officially treating online commentary as a financial conspiracy to damage her brand, and she wanted to expose who was behind it and who was benefiting. Soon after the subpoenas became public, Blake Lively's legal team issued a carefully worded press statement to Variety claiming that the goal was not to silence creators but to trace the coordinated amplification of false and damaging narratives. The statement continued public commentary that misrepresents legal facts, and court proceedings, especially for profit, fall under a different standard of scrutiny. Our subpoenas seek to identify whether individuals knowingly spread falsehoods while benefiting financially from reputational harm inflicted upon Ms. Lively. This line raised red flags for legal analysts across the board because the implication here is huge if Blake's team is successful in framing independent commentary as malicious profit-driven disinformation, it could redefine how public figures go after creators. In court, it could open the door to lawsuits, not based on defamation, but on financial damages from narrative shaping. In simpler terms, talking about celebrities online could become legally risky, even when it's based on public information. And that's terrifying. Brian Friedman, attorney for Justin Baldoni, didn't hold back when asked about the subpoenas. It's intimidation, plain and simple, he said in a phone interview. When you lose a case like Jed Wallace's and yours, the next move is to go after YouTubers and commentators. That's not about the law. That's about ego. That's about trying to bury voices that embarrassed you. He added that no court in the country has ever upheld the idea. That's simply earning ad revenue from commentary that constitutes conspiracy or targeted defamation. This is a fishing expedition, Friedman said. And courts don't like fishing expeditions, especially when they target speech. Other First Amendment scholars chimed in as well, calling the subpoenas a potential chilling effect on creator-driven media and a misuse of civil litigation tools to enforce PR control. Still, Blake's team is pressing forward, and it's becoming clear they're not backing down. According to multiple insiders close to the legal teams, this move was in the works for weeks. Some claim Blake's team was enraged by the sheer number of viral videos breaking down the courtroom developments, especially the ones that exposed contradictions in her filings. One legal insider revealed there was a war room meeting the day after the Wallace ruling. They didn't just talk about how to pivot legally, they had YouTube clips on a monitor. They were analyzing who said what, how many views it got, and what timestamps were damaging. This means they aren't just reacting emotionally, they're building a strategy, a PR legal hybrid that sees creators not as random critics but as organized players in an image war. Some believe Lively is preparing a broader legal theory to file an amended defamation complaint, not just against Baldoni but against a list of creators who, in her team's view, monetized her pain. That phrase alone, monetized her pain, is becoming a rallying cry in Hollywood legal circles, because if that theory holds, anyone with a platform could be at risk. By the time the dust settled from the Jed Wallace dismissal, the subpoenas had already gone out, quietly, surgically. Blake Lively's legal team wasn't blasting them in, they were sending them straight to inboxes and attorneys, each one stamped official and worded with unnerving precision. Among the first to be hit were creators who had steadily covered the Lively versus Baldoni conflict since the beginning. These weren't gossip channels or drama chasers. Some had videos topping 1 million views with titles like Blake Lively's legal strategy just collapsed, and why this, arguing that the requests are overly broad, invasive, and intended to intimidate. Legal watchdogs are watching closely to see how judges will respond, because if these subpoenas stand, it could set a new alarming precedent. Behind-the-scenes whispers of a digital blacklist have started to circulate. Some PR insiders claim that